In order, it stand for the Pledge of Allegiance, please.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
It's not on here, but if anybody wants to silence their cell phones, could you do that? Okay. Resolution number 2017-03-30-18. A resolution of Sun and Lake of Sebring Improvement District to approve the settlement agreement to conclude the litigation with Gregory Griffin and approve budget amendment number 4 to fund the settlement. Do I have a motion to approve the action agenda?
I so move.
Second.
Good afternoon. My name is Brian Koji. We've met once before. What you have before you today is this settlement agreement in the Greg Griffin versus Sun Lake case. That case, just to bring you up to speed, I'll give you a synopsis of where we are and what we're asking you to do today. And then if you have any questions, I'm happy to answer them. As you know, my name is Brian Koji. I've been defending the district and Mr. Halbig in this case. I still represent both the district and Mr. Halbig. As you may have heard recently, we got the court's summary judgment order, which disposed of part of the case, but did not dispose of all the case. So the claims against Mr. Halbig were dismissed. The First Amendment claims against the district were dismissed, and the bulk of the FMLA claims against the district were dismissed. What was left in the case to go to trial was the whistleblower claim against the district and a small piece of the FMLA case against the district. Technically, they have the right to appeal that dismissal. So again, my capacity, I'm here on behalf of both the district and Mr. Halbig because they could appeal it if the case is not resolved. The trial was scheduled to start April 10th in front of Judge Rosenberg over in Fort Pierce. And what's happened since that time is that the parties in light of this summary judgment order have discussed settlement. As you may recall, we had a mediation ordered by the judge in February, and we were unsuccessful at that time in settling it. But we have successfully reached a tentative agreement right now, subject to the board approval. The settlement essentially is similar to the offer that we had made back in February after the mediation. But the settlement essentially is a breakdown. The total cost of the settlement would be Greg Griffin and his attorney combined would be paid a total of $368,000. That's broken down as $18,000 in wages to Mr. Griffin, another $125,000 to Mr. Griffin as compensatory damages, and then the balance, which is $225,000, would be for attorney's fees paid to his attorney. The district would not pay that full amount. The bulk of it is being paid by the insurance company. What the district would pay, if you approve the settlement, is $109,000 of that total $368,000 amount. The balance would be paid by the insurance company. They have approved it. The only thing left is for you to consider whether to approve it. Mr. Griffin has signed the agreement. He signed that yesterday. So if it's approved by the board, it would get signed today and the court would dismiss the case. Right now, the case has been stayed. If it's not approved, the court's indicated it would go forward possibly on April 10th. She might move it back a week. I'm happy to answer any questions. You have, I believe, the agreement and release. It's a general release. What that means is everything that's happened up to the time the parties sign off on the agreement is waived. Neither side can sue the other side. As part of the claims, he has to dismiss his claims. He cannot file any appeals, both against the district and Mr. Halbig, and we can't sue Mr. Griffin. So everybody would go their separate ways, and he would separate his employment voluntarily. If we go to trial, he's claiming reinstatement. He's going to not only seek damages, but to keep his job. If there are any questions, I'm happy to answer.
I had one. What is the major amount that we would be responsible for if we went to trial and lost?
I'd break that up into two different possibilities. If you went to trial and lost, he's seeking reinstatement to his job. He's got interim reinstatement at the present time, but at the end of the trial, he would seek permanent reinstatement. If he were permanently reinstated and you lost on the whistleblower claim, then you would be on the hook for back pay and benefits. I ballparked that, calculated that out to be about $130,000. That he's been off since September of 2015. He was reinstated and paid effective January 20th, I believe it was. So that interim time period, pay and 401k contribution. He would get reinstatement, sorry.
And that would be all in the district. The insurance would not cover any of that, correct?
That's correct. All back pay and benefits and the reinstatement would be 100% on the district. Insurance does not cover that. Now, the second group is if we took the position that he should, even if he won, he shouldn't be reinstated. There have been some changes and reorganizations, and we did not want to reinstate him. In employment cases such as this, if we can convince the judge that it doesn't make sense to reinstate him, they will not reinstate, but then they will put front pay on top of the back pay. So typically it's about 2 years, so you can get 2 more years pay. I ballparked that with the back pay to be a neighborhood of $430,000. I would expect a plaintiff, though, always argues for about 5 years. I don't think the judge would give him 5 years, but bottom line is with reinstatement, we're looking at 130-ish if we lost. Without reinstatement, if we lost, we're looking probably in the neighborhood of $500,000, less shy of that. And that's all on the district. If he won compensatory damages as well, so FMLA, or if he were successful in bringing the First Amendment back in, he could get emotional distress, mental anguish, but that would be paid by the insurance company. He would also be entitled to attorney's fees, but that again would be paid by insurance.
But our total could be $500,000.
It could be, yes. If we lost the case, I would expect the most likely outcome would be either reinstatement with 130, 150, or no reinstatement, close to $500,000.
He's already signed this agreement, right?
He has.
The problem I got with the agreement is on page 1, number 1, it says about 6 lines down, prior to the date. And to me, if we're going to have an agreement with this guy, that should be taken out, because basically, if I'm reading this correctly, it's saying tomorrow he can come back and sue us again.
Yeah, let me speak to that, because I think I understand where you're coming from, but the intent of that is right now he cannot sue, even if you were to approve and we were to sign it, he couldn't sue you tomorrow for anything that's happened to date. The reason that language is there, he could still sue, and you could sue him, or anybody could sue him for things that haven't happened. So the example that comes to mind to me is if next week everybody signs off, or next month a district vehicle rear ends him, he can sue for that because it hasn't happened. Under Florida law, we can't require him to waive causes of action in the future that haven't occurred. So what we have here is essentially he can sue for anything in the future that hasn't happened, but he can't sue even in the future for things that have already happened. That may not be as clear, but this is as strong as you can get on the release. We couldn't require anybody to sue for things that have yet to occur. So that's all that language is meant to cover.
I understand all that, but I just, knowing this guy's background,
Doesn't number 5 cover that?
Number 5 is the general release paragraph, and number 1 is similar. Number 5 says you can't sue for anything. Number 1 adds on to that and says what you have, you got to withdraw. You can't file anything else. But yes,
Right.
They go hand in hand with one another, and neither of them allow you to sue for future claims that have yet to accrue. But we couldn't require that under Florida law anyway. But right now, everything he has, if you had hit his vehicle last week, for example, even though it's not part of the case, he can't sue for that.
Okay.
And since he won't be working for the district if this is passed, in theory, there should be very little opportunity for anything else to accrue, unless something strange like that were to occur.
Could you clarify? Oh, I'm sorry.
I was just going to say, the other concern I had was number 14, but I've already been told that that's standard Florida language, and nothing we can do about
The
that.
consideration of revocation periods are required to have the complete release that we have. They're required by law. If
He
we
signed
took
it.
that out, we would have to carve out some of the release.
Okay, that's what I was going
So
to
that's
ask.
the 7 days that he has.
I don't mind the 7 days so much, but it's the 21 days. that I
Well, the
don't-
good news, I'm sorry to cut you off, the good news is the 21 days is only good until he signs it. So by him already signing it, that waives the balance of that. So the only thing left is the 7-day period. In theory, yes, he could revoke the agreement up until next Wednesday.
That's-
Once Wednesday rolls around, it's done and over, but that's required by law, so it's not something that they've asked for, or we've asked for, it's just a
Well,
boilerplate requirement.
Yeah, it was the 21 days I didn't like, because that puts us past the trial date. And now he's kind of got A/B kind of thing in his hands, so. that's
Yeah,
what
as
I
a
did.
practical matter, if it weren't required, it wouldn't be there, but since he signed it, it's no longer of any value to either side.
All righty, I'm done.
Mark?
Yeah, actually, I was thinking about 14 as a rescission clause there, but you've explained it, and it's Florida law is Florida law. I do have a question, and I don't know, will our risk management, what kind of hit will we take on that financially? Do we have a feel for that?
I don't as of today, no.
I can't speak to that. I have honestly no idea what the ramifications of that would be.
Okay. No prior history, so you would know.
It's not on my area. I don't really
Okay.
get involved at all. I don't know what your rates are or what you pay today, so I certainly wouldn't know what they would be down the road.
Just curious. Secondly, it discusses in here a little bit about bids under, I think it's under, let me see, I had it, 4.
I saw that.
He can't
For-
bid for 6 months.
Last sentence of paragraph 4.
Yes, and it says, if I read this correctly, technically he cannot respond and do any work for us, but after 6 months he can.
Correct. Yeah, it's basically, it's saying that he's not going to submit any bids, through any, the paragraph, and we had discussed that, we tried to get a longer, time. We tried to make it indefinite, but the courts generally don't like indefinite, any sort of indefinite terms. I mean, 20 years from now, or 10 years from now, 5 years from now, none of you may be back, may be on the board. We may have a new general manager, a million different things could happen, and Griffin shouldn't be precluded from at least applying for a job. There may be some job that the different district has and needs that he's qualified for, and if we're dealing with a completely different set of board members, and there could be a situation could arise where he would, he should be allowed to at least apply for a job. We wanted to include that and like say the part about the bids, we talked about a 5-year provision or a 2-year provision or any provision, but when we started discussing it with his attorney, she started intimating that might require additional compensation if he was, because while it says that he personally can't, reapply for a job that the district has, it wouldn't prevent him, some company that he has a controlling interest in from submitting a bid. And at the same time, we didn't want to hamstring the district. The district wants to get the best job it can for the best price it can. And if he happens to be, the company that can provide that, we should at least consider. We shouldn't, immediately, throw them out as a matter of course. We figure 6 months is the time that they came back with, and hopefully, time will heal some wounds. And in 6 months, if we have a project that he's qualified to bid for, we at least owe him the. We don't want to prevent him from submitting that bid.
Yeah, and the good news, I think, too, is that one thing is it doesn't give him any extra rights. In other words, even after 6 months, he could bid, doesn't mean you have to award it to him. You have every right you already have, so, and there's nothing that says you can't consider the past, although you wouldn't be able to retaliate against for filing lawsuits, but past performance and things like that, whatever you would with any other bidder, you could still do. But the intent of putting something in the agreement there is we didn't want anybody to sign off an agreement and tomorrow reapply for the job or submit a bid, then if they don't get it, come back and try and sue, that kind of thing. So we try and have this cooling off period, no reemployment at all, since he does have a side business, have some period where he can't even bid, so we don't have to deal with the question. That was the intent of that provision.
Anything else, Mark?
No.
Wally?
No, so our total payout to him will be $109,000.
109,000, correct.
Nothing additional Nothing hidden.
Nothing additional. Part of the allocation is a wage payment. It's 18,000, so there's payroll taxes for both sides on that, but it's pretty minimal.
Larry?
You've answered all the questions that I had, so.
My only question is, I'm assuming that the insurance company and you think this is our best thing we should do. Am
Yeah,
I correct?
I'll answer on both, yes to both. The insurance company definitely signs off on it, and they think that it's a good deal, given the risk uncertainty. The case could go either way. We think we've got a good defense. We've talked about that before, but he's got timing, and it just depends on kind of jury. There's a risk, particularly with the potential for reinstatement to the district, I think, and the fact that the insurance company, if it does go against us, does not cover the back pay or front pay part. I think this is the best deal you're going to get, and I would recommend you settle the case.
Well, I agree with that on the aspect that I know that, that civil cases seldom ever go to trial in the federal court, so, because no one wants to face a jury. You know, so, and this seems to be, in my opinion, the best way of settling this issue and moving on. I mean, you know, it was handed to us, so we have to make a decision.
Is there public comment?
Rick Hulbert. It sounds like we're just going to bite the bullet on this. From all the things that I know about Greg Griffin and the way he was operating here in the district when I was on the board, the things that he pulled on us when I was on the board, I feel that I don't know why we aren't taking a better chance and why our attorneys don't feel that we had a better chance at going to court and going to sue him, because he did things that weren't correct. I mean, he was running businesses while he was working for us. He was on sick leave. And yet he was down in the Bahamas on vacation. He was playing golf here on the golf course while he was on sick leave. Now, how can you do that and be on sick leave? And it doesn't make sense to me. Now, all these things were brought up in our depositions when we did it for the district. And it just doesn't seem right to me that he's getting away with this. Now, can you answer those questions?
I'm happy to address it if you guys want me to address them with that. I don't disagree with what Mr. Holbert is saying, in the sense that we have and we think we have a good defense to the case, but it's a coin flip as to whether we can prove that to the jury. Part of the issues, Mr. Griffin certainly had some issues with his job performance. I think that's pretty clear that there were numerous projects that didn't turn out the way we would like them to turn out. The issue that a jury would have to grapple with is whether that was the reason that he was let go.
No,
And so
I'm talking about running his other businesses while he was working for us.
Understand, but he was doing that for 3 years and he wasn't terminated, is the question. That's what they'll say. And we've got Michael Wright, a former general manager, who is going to testify on his behalf. So just from a standpoint of whether or not we could convince the jury, it's a toss-up. And I'm not saying we would lose, and I haven't said that at any point. My opinion has not changed on the case, but I can't sit here and tell you you're going to go forward and win either. So to me, do you roll the dice and flip the coin with the ramifications being here's what you might end up paying, or do you take the shot? That's ultimately your call.
afternoon, Larry Bertetto. If it's sort of a no-win, I mean, we're getting out of it probably that he's only going to get $109,000, and we're basically footing the bill for his attorney, is what the way I interpret it. Is that's correct?
No.
No.
Our insurance is paying.
Or I mean, yeah, excuse me, on insurance. So that's now he can't come back and sue us. And you mentioned that in 6 months he can apply and bid. Is that correct?
Correct.
Okay. And if we remember correctly, several weeks ago there was a company in here, and I forget what they came to bid on, and Mr. Griffin was part of that company that was here, and the board turned it down. Where would we stand if Mr. Griffin bids or comes in? He owns, we know that he has 3 or 4 different companies, and if he comes in and bids, or those companies bid, or any friends of his that he's connected with, and we reject it, where do we go to court again to defend our actions that we turned him down?
If he bids after the 6-month period of time, you would consider his bid as you would anybody else. If you turn it down, you would want to have a legitimate reason to turn it down. Presuming you had that, it would be lawful. Could he sue and claim you didn't? I'm sure he could, but again, all that he can claim is retaliation. Going back to what happened in 2014, 2015, from my vantage point, the good news for the district are the people that he was complaining about are no longer on the board. So it'd be a much tougher sell if he's going to come in and say, well, you turned down this bid because I criticized Mr. Halbig or Mr. Miller when they're no longer on the board.
Okay, thank you.
Anybody else? You guys have anything else?
Yes, sir.
Tanya, this is going to be a transfer of 91,000, correct? And the 18,000, is that coming from for a spot that we had?
Yes.
Okay. That we still have on the books? Okay.
We had in our budget, starting the fiscal year, we had a director. Oh, there you go. During the budget process last summer, we budgeted for a district engineer, and essentially that job was in the budget going forward, so that those are monies that we do have currently that we can use the 18,000. So no budget amendment would be required for that.
Just wanted to make sure. Thank you.
No other questions. Chrissy, I guess, roll call.
Supervisor Edel?
Yes.
Supervisor Camp?
Yes.
Supervisor McCullough?
Yes.
Supervisor White?
Yes.
President Gilpin?
Yes. Discussion to and from the board on anything?
I'd love to say a lot, but now's not the time.
No.
Yeah.
There will be more.
I totally agree on that, and I'd just like to, so we're going to present this to the judge, motion to dismiss and so forth?
The judge stayed the case pending the vote today and has asked me to file a notice no later than tomorrow to let her know if it was approved or not. If it's approved, she'll just dismiss the case. So,
And we'll be notified then? I'd just like to
yes.
see that judge's signature on that dismissal.
yes,
before that matter.
absolutely. There'll be an order, and we'll forward that to Tanya and to David. I
Yeah.
assume you'll forward it to the board.
Yeah.
Then we can discuss.
Okay, we're adjourned.